Hi, I'm Tabitha Taylor. I'm a business law attorney in Florida, and my job is to protect small business owners from the unknown liabilities that they are oftentimes subjecting themselves to. Now, today I'm going to talk to you about the terms and conditions section on your website, and I'm here to tell you what those essential provisions are that you should have. Once we have them all drafted, it's important that you actually post them to your website so that you can take advantage of those strong provisions that you just finished drafting. And to do so, take a look in the description for a link to Nicole Stock's video, where she goes through and shows you how to actually add the terms and conditions to your website. She's a fantastic web designer who can help you DIY it, or she's also available for consultations to take that stress away from you if you prefer the hands-off method. Now, first of all, let's talk about what terms and conditions are. Well, they're exactly what they say they are. They're the terms and the conditions that anyone using your site agrees to be bound by when they're using your site, which using your site could mean something like making a purchase. It could be booking an appointment with you, or it could be something as simple as downloading a free resource. They're going to your site, they're inputting information, and they're downloading something off of your server. Now, you've likely seen this on many sites before, and sometimes they're called different things. Sometimes they're terms of use, sometimes they are privacy statements, terms of service, but for today's purposes, I'm going to be referring to them as your terms and conditions. So your specific terms and conditions are going to depend upon what you're actually using your website for. What's the purpose of your website? Is the purpose of your website to sell a product and have individuals purchase that product directly from your site? Is the purpose of your website to book appointments, to have clients book directly from you online, whether it's a paid consultation or free consultation? Either way, they're booking something with you online. Or is it just to disseminate information? Maybe you have a blog, something of that nature. Now, in general, the purpose of your website will dictate the specifics of your terms and conditions. Terms and conditions can be very, very lengthy. I'm sure everybody has seen Apple's or Word, Microsoft's terms and conditions. They can go on for pages and pages. You oftentimes just scroll to the bottom and hit next or accept, and that's that. Yours would probably be fairly short, maybe anywhere from 3 to 7 pages, depending again on exactly what your purpose of your site is. But there's still provisions in there that every single individual company, regardless of the industry that you're in, is going to have in your terms and conditions. So today I'm going to review the 4 main provisions that everyone should have in their terms and conditions. And regardless, again, that's going to be regardless of the purpose of your website. So the first is going to be liabilities. This provision basically tells the user that they are navigating your website at their own risk. It's a limitation of liabilities. It can prevent you from being liable for any damages to a certain extent that may occur if something were to go wrong while a user is on your website, while they're navigating your site. Say, for instance, that you host other people's websites and they purchase those web hosting services from you via your website, and then your website server were to go down, or if they were to submit some information on your website and now that information has gotten lost or been disseminated to the wrong party, you want to make sure that you have limitation of liabilities provision in your terms and conditions, because in the event that something goes wrong, you want to limit the amount of exposure that you have. Without this, the potential possibilities can be endless. So in those instances, if something that they are purchasing from you off of your website, if there's an issue with it, and they now want to sue you for any, let's just say they lost profits that day, or because you wrongfully, or they're going to allege that you wrongfully disseminated their information, their email address, their phone number, whatever, maybe even their credit card statement, or credit card information, you want to make sure that you disclaim any responsibility for potential damages that they may be incurring. Having this provision in your terms and conditions can save you thousands from lawsuits. Now, The second most important provision to have in your terms and conditions is going to be a privacy statement. You want to let your users know that you aren't really collecting any of their private information, or if you are, what you're using that private information for. Now, the private information or the personally identifiable information that you're collecting from them, make sure that they are aware you're only collecting the personal information that they are voluntarily giving you. You're not putting trackers on their computer and hacking in and getting, their passwords or their home address if that's not something that you're actually collecting from them. So you want to let your users know that you're not collecting their personal info aside from what they've provided voluntarily. And voluntary things could be information that they put on a contact me form or an order form, such as their name, their address, their phone number, email address, etc. And you want to advise the user that you're keeping this information safe and that you're not selling it to anybody else. Or if you are, you want to make sure that you advise them of that in this section. Hey, you're providing me with this information, with your email address, etc. It may be sold to third parties, and by using these agreements, you're consenting, or by using my website, you're consenting. So that's a very important provision to have in there, is to let people know what you're doing with their personal information. It can also be used to make the user aware that you're using cookies. So maybe you're using cookies to track them for targeted marketing. So, they went to your website once and now you're using cookies so that you can repurpose your marketing and do pay-per-click. Your ads can now pop up in their Facebook or their Instagram, whatever it may be. So it's very helpful because this section essentially lets the user know how your website plans to use their personally identifiable information, so that they can't later say, well, I had no knowledge that you were collecting this info, or you didn't have my permission to use this information. It's also very helpful to include a paragraph or two in your privacy statement that tells your user about any security measures that you might have in place to protect that information. So yeah, okay, we're getting your information, but here's how we're going to protect it. Generally speaking, for this protection provisions that you want to include embedded within your privacy statement, it can be something very short, sweet, and to the point, along the lines of, we are exercising reasonable care in providing the secure transmission of information between their computer and your servers, but that you also cannot ensure or warrant the security or safety of that information in the event, or while that information is being transmitted over the internet, in the event that something may go wrong, because you cannot guarantee the security and safety of any information over the internet. There's hackers out there all the time. So this allows you to disclaim the responsibility for any unintentional disclosure. And your privacy statement should also protect you from any wrongful privacy practices that other websites that are linked to your site might have, or any third-party advertisers. If you have let's say you have affiliate links on your site, or if you're citing to another site in one of your free downloads, you want to make sure that in your privacy provision, or in your privacy provision within the terms and conditions, that you are disclaiming any wrongful practices. If they do something wrong and they're not protecting information, or they have a virus linked to their site, something along those lines, you're not responsible for that. So that is a very important section to include in your terms and conditions. The third most important section is what happens when a user wants to sue you. Even the best attorney in the world cannot prevent someone from suing you. And generally speaking, anybody can sue you for anything. Now, you can have the best, most ironclad terms and conditions on your website, and you can still have a user sue you for something related to their use of your site. That doesn't mean that their lawsuit has any merit or that they'll win. It just means that a lawsuit can still get filed. So with that in mind, you want to dictate how and where that is allowed to happen. So this section is your arbitration clause. You want to ensure that any dispute that's brought under your terms and conditions is required to be brought and resolved via arbitration. There are so many benefits to you as the company for requiring arbitration. In general, arbitration is faster, it's cheaper, and plaintiffs hate it. So the traditional court system, just as a slight tangent, is incredibly slow, incredibly inefficient, and plaintiffs love it because they just drain the defendant's money and usually can get you to a settlement. And they also get a jury trial that way. Well, in arbitration, it's generally a lot faster than the traditional court system. It's going to be more affordable because you're not in litigation for years. You're in a litigation for a small amount of time, or really you're in arbitration, but it's a type of litigation. And the plaintiffs don't really care for it because it's a binding decision. It's very difficult to appeal, and they don't get the jury. So you get to call the shots. You get to dictate what happens when they sue you. So step number one is dictating arbitration. Step number two is where do they get to sue you? So remember, an arbitration provision mandates that if they want to sue, they have to use arbitration rather than the traditional court procedures. But you also want to dictate where that arbitration is going to take place. So if you live in Florida like me, you don't want someone who lives in Alaska to try to sue you in Alaska, because then you have to defend the lawsuit in Alaska. Now, instead, you want to make clear where the arbitration is going to be, which is, in my instance, would be Florida. Specifically, you can even name your county. I would name Broward County for any lawsuits that were going to be filed or any arbitration that was going to be initiated. So this is called your jurisdictional provision. It can also be where you include your choice of law provision. So Florida law will govern. The jurisdiction will be in Broward County, Florida. And you can include this alongside your arbitration provision altogether. Now, the final provision that is incredibly important in your terms and conditions. And when my clients come to me with what they think are terms and conditions, and then they either have an issue with the user or just out of an abundance of caution, they ask me to revamp it for them, I oftentimes do not see this in their terms and conditions. And it is the most important section, which is ironic because it's the entire point of having a terms and conditions section in your website. I strongly, strongly recommend that my clients have this in bold, maybe even underlined, and it usually comes at the very end. This is your acceptance of the terms and conditions. It's a relatively short provision, and it simply states that by using your website, that the user accepts the privacy statements, the privacy practices, the various terms and conditions that you have set forth on your page. For good measure, I would probably even throw in a line or two about how you can change your privacy provisions, your privacy statement and your terms and conditions from time to time, and their continued use consents to any changes. But this is very important because you want to be able to say, listen, you saw my terms and conditions, and it states in there that by using my website, by making a purchase, by booking an appointment, by downloading a free resource, you're agreeing to be bound by these terms and conditions. And so this is what is the most important provision out of everything that you have in your terms and conditions. So overall, these are the four main provisions that every single person should have in their terms and conditions on their website. If this was helpful, please don't forget to like and subscribe. You can also check out the description for more free resources from our law firm, Bryant Taylor Law, or you can even book a consultation with us if you want to chat a little bit more with me. Or again, if you don't want to DIY your terms and conditions, I'm happy to draft them for you. So just book a consultation. You could do so in the link below. DIYing your terms and conditions can be fun sometimes, but it can also be incredibly time-consuming and overwhelming. So we're here when you need us. We also have free newsletter we send out every month and a lot of helpful information to keep your business protected from those unknown liabilities that pose threats to all business owners. So again, make sure to check out Nicole Stock's video on how to upload the terms and conditions to your website once you have them drafted. Thank you so much for watching.